890 words within the 5% target range. Script written to Hidden Rule Consent Decree Script, TXD. There is a legal mechanism called the consent decree. No one voted for it, it appears in no statute you have ever read, and one signed in 1941 still binds an entire American industry today, more than 80 years later. It was never repealed. It cannot be repealed. Not by Congress, not by a president, only by the same courtroom that wrote it in the first place. A consent decree is not a law. It is a settlement, an agreement between the government and a private party filed in federal court that ends a lawsuit before a verdict is ever reached. The defendant agrees to change its behavior. The judge signs off. From that moment, the agreement stops being a private deal and becomes a standing court order, enforceable like any other judgment, backed by contempt power. No legislature drafts it. No floor vote happens. No president signs it into law. A single judge in a single courtroom converts a negotiated settlement into something that functions exactly like permanent legislation. For one company, one industry, sometimes one city, indefinitely. The one still running is United States v. ASCAP, entered in 1941. The Department of Justice sued the American Society of Composers, Authors, and Publishers for operating a music licensing monopoly. Rather than fight it out at trial, ASCAP agreed to a set of restrictions: how it could price licenses, how songwriters could be represented, how radio stations, bars, and streaming platforms would eventually be charged to play music. The judge entered the agreement as a decree. It became binding. Congress was never involved. No elected body ever approved the terms that, to this day, govern how almost every business in America that plays recorded music pays for the right to do it. A sister decree bound BMI the same year. Both outlived the men who negotiated them by decades. Here is who actually controls it now, not Congress, not the Justice Department that filed it in 1941, and not ASCAP itself. It is whichever federal judge currently sits in the Southern District of New York holding what is informally called the rate court. Under the decree's terms, if ASCAP and a broadcaster or a streaming service cannot agree on a licensing fee, that single judge sets the price. One person, unelected to that specific function, appointed decades after the original case closed, effectively acts as the price regulator for a meaningful share of the American music economy, a role Congress never created and has no direct mechanism to reassign. Here is the part that should actually worry you. The decree does not just set prices. It defines who counts as a rights holder in the first place, how disputes are resolved, and how new technologies get folded into an 80-year-old framework. When streaming exploded, the decree did not get rewritten by lawmakers who understood streaming. It got reinterpreted by a court applying 1941 logic to 2020's technology, because that was the only body with authority to touch it. Songwriters who signed nothing, voted for nothing, and were not born when the decree was entered are bound by its terms every time their music is played. A small business owner playing background music in a coffee shop is operating inside a legal structure built to break up a monopoly during the Roosevelt administration, with no path to petition a legislature to change it, because no legislature holds the pen. And here is what should trouble you even more: this is completely legal. Every part of it followed the rules. That is exactly the danger. It cannot be repealed the way a statute can, because it was never a statute. Repealing a consent decree requires one of two things. The party that agreed to it must return to the same court and successfully argue the decree's purpose has been fulfilled, or the government itself must file a motion to terminate it. In the ASCAP case, the Justice Department did eventually move to modify it in 2019, not repeal it, modify it, and only after years of industry pressure, and only through the same judicial channel that created it in 1941. No ballot initiative reaches it. No new Congress can vote it away with a simple majority. It exists in a legal category built specifically to sit outside the normal mechanisms of democratic reversal, because it was designed as the resolution to a lawsuit, not as policy, and lawsuits, once settled, are not meant to be reopened by public opinion. This matters far beyond music licensing. Consent decrees govern police department reform agreements, hospital systems, telecom mergers, and entire municipal utilities. Each one a permanent feeling rule, negotiated in private, ratified by a single judge, binding on people who had no seat at the table and no vote on the outcome. Every one of them was legal. Every one of them is enforceable exactly like a law, without ever having been one. The pattern repeats across dozens of industries you assume are governed by Congress, when they are actually governed by settlements frozen in amber decades ago. So the real question is not how many consent decrees are quietly running your life right now. It is how many of them nobody has bothered to check on since the ink dried.